Many taxpayers and a lot of their representatives use the terms tax evasion, tax fraud, and false statements as if they mean the same thing. Well, under federal and state law, they don't. And that distinction matters because the statute the federal or state government chooses determines what it must prove and how severe the consequences can be. Hi, I'm David W. Klasing. I'm a dual licensed tax attorney and CPA, and I'm the owner of the tax law offices of David W. Klasing. To date, we have 24 locations in 11 states to serve you nationwide. Today, I'll explain the difference between tax evasion, tax fraud, and false statements, and why understanding those distinctions is critical in a high-risk tax matter. So what does tax evasion really mean? Tax evasion is defined under Internal Revenue Code Section 7201. It is the classic felony tax charge. The government must prove a tax due and owing, an affirmative attempt to evade, and willfulness. This offense carries up to 5 years in prison per count, plus substantial fines. The key issue is affirmative conduct designed to conceal the truth. The IRS looks for actions double set of books, having false invoices, destroying records, concealing assets, using nominee entities or structures to hide taxable income, and giving false explanations to agents. A failure to pay or a failure to file by itself does not automatically become tax evasion. The government usually needs evidence of concealment or deception. Tax fraud is an umbrella term. In the civil context, it refers to 75% civil fraud penalty over. In the criminal context, it describes intentional tax cheating that may be charged under several different statutes. So tax fraud does not refer to one single federal crime. Let's talk about false return charges under Federal Section 7206(1). This section focuses on materially false tax documents signed under penalties of perjury. The government doesn't need to prove a full tax evasion case. It only needs to prove that you knowingly signed a materially false document. This offense carries up to 3 years in prison per count. False statements can trigger 18 U.S.C. Section 1001. This applies when taxpayers lie during taxpayer interviews, or they submit doctored documents after the fact, or they conceal material facts during audits or criminal tax investigations. In other words, the criminal risk may arise after the return is even filed. So why do these distinctions even matter? Well, each statute has different elements, different proof requirements, and different strategic defenses. That's why an effective defense begins by identifying what the government could actually charge and not simply reacting to the word fraud. So in closing, if you underreported income, you claimed unsupported deductions, you signed materially false returns, or you made statements to the IRS that may not withstand scrutiny, this is the stage to act. At the tax law offices of David W. Klasing, our dual licensed tax attorneys and CPAs handle both civil and criminal tax matters on a daily basis. Call 1-800-681-1295 or visit klasing-associates.com to schedule a confidential reduced rate initial consultation today. Dave Klasing, Tax Attorney CPA.